Hi, everyone. Thank you for joining today's webinar presentation, Myths of Litigated Patents. I'm Allie Morton, Product Marketing Manager at LexisNexis IP, and I'd like to just cover a few things before we get started. During the webinar, please feel free to submit questions using the questions feature in the control panel. Also in the control panel, you'll see the handout section. That's where you can find all of the files pertaining to today's webinar, including the slides. A follow-up email of the recording along with the slides from today's presentation will be sent to you later today. Now I would like to introduce our presenters. With us today, we have Dr. Sean Tu, the Associate Dean for Faculty Research and Development at the West Virginia University College of Law. Prior to beginning at WVU, he was an associate at Foley & Lardner. He also spent time as a research assistant for Judge Posner of the U.S. Court of Appeals for the Seventh Circuit. Sean received his law degree with honors from the University of Chicago Law School and his PhD in pharmacology from Cornell University. Also joining us today is Megan McLaughlin, the product director for LexisNexis Patent Advisor. After graduating from Harvard Law, she worked as a patent attorney at the law firm of Nutter, McLennan & Fish. Her technical focus reached into a variety of industries, including medical devices, the food industry, software, printers, and biotech. And last but certainly not least, we have Jean Quinn. Jean is the founder of IP Watchdog, a patent attorney, law professor, and leading commentator on patent law and innovation policy. Jean has been named one of the world's leading IP strategists multiple times by IAM Magazine. Thank you again, everyone, for attending today's presentation. And with that, I will turn it over to you, Jean.
Great. Thank you very much, Allie. And we appreciate you all being here with us today to spend a portion of your Thursday with us, wherever you may be. And one of the questions that we always get before we get going too much into the substance is whether or not you can get these slides. And you can, in fact, get the slides. You can download them right now to your computer. If you're on your computer listening to this, you will have your GoToWebinar control panel. And one of the tabs there is going to be handouts. You could just click on that, and we have 3 handouts for you today that you can download right to your machine. And please feel free to share those with anybody else who's listening along with you here today. So thank you again for joining us here today. And what I'd like to do is I'd like to start by bringing in our panel. We have a lot of slides to get through today, a lot of interesting stuff, a lot of things that maybe are not going to be what you would expect them to be. And I think we're really going to scratch the surface here of an issue that we are going to pursue doggedly, I think, because this could be quite important and for everybody to know and incorporate into your practice. So before we get going, though, on this journey, I'd like to get your thoughts, Sean and Megan, about what it is we're going to talk about today, big picture. What do you want people to be thinking about in terms of examiners who have patents that are litigated? Megan, let's start with you, and Sean, I'll ask you the same question next. Megan.
Yeah, so as patent attorneys, we put a lot of effort into making sure that our patents will stand up to litigation, right? And it's a hard job because sometimes the very thing that's going to get you through the patent office is the same thing that's going to destroy your patent in court. And then of course on top of that, there's the fact that the case law, particularly in some areas, is a moving target. But there's another factor in the equation that can really affect what happens to your patent after it's granted, whether it gets litigated and then what happens in that litigation. And that's who the examiner that your patent is assigned to. Spoiler alert, today we're going to find that there are some real actual correlations between your examiner and what type of examiner you've been assigned to and whether or not your patent ultimately gets litigated. So obviously you can't control which examiner you're assigned to after you've already been assigned to them. But if you know that your particular examiner is more likely to issue patents that ultimately get litigated, you can be proactive in trying to minimize that risk during prosecution. So hopefully today, if you come away with some real insights about these correlations and how you can be proactive.
Yeah, and today we're going to talk a lot about correlations, and I'm always reminded that the people who don't like the information that we provide, particularly like on IP Watch, like for example, whenever we talk about correlations, people will say, well, correlation is not causation. Yes, I get that. Correlation is not causation. But when correlation becomes overwhelming, it requires further investigation and consideration about whether or not that correlation is meaningful. And I think, Sean, your data here suggests that there are some stories that could explain some of the correlations that we see that make common sense, but are not necessarily what people would think in the first instance.
No, absolutely. And to answer your question, the question that you asked, Megan, I think the take-home message that people need to understand is, who you get as an examiner may really guide if something goes into litigation or not, which is really interesting to me because it may have less to do with the substance of your prosecution, the substance of your patent, and more to do with the examiner promotion schedule, which is a really crazy thought if you think about it. To who gets sent to litigated patents. And to kind of get to your correlation causation, there are things that the patent office could do to kind of address this issue. And then if we see litigations go down, then you can get more to the causation question. And again, I was a research scientist for 10 years of my life, and that's exactly what we did. We experimented by changing one variable and seeing what happened. And I think these are things that the office should really look into.
Yeah, because excuse me, because if this correlation is correct, what we think we're seeing, some small changes could address it, and that would potentially greatly impact the litigation landscape. And knowing about it could also help you in the meantime. And what I'm going to say is, and we have one comment here, it's hard to believe practitioners are going to be surprised. Surely they realize which district judge they're litigating and effects and outcomes. We're not really going to talk about the outcomes today. We're going to be looking at outcomes later on. This is, again, a series that we're going to be doing. We're going to be looking at this long term. What we're looking at today is, do patent examiners have certain characteristics? Do these characteristics that examiners have that we know that they have? That, for example, some examiners issue patents quickly. Some examiners issue patents and take a very long time to issue patents. Some examiners are more junior than others. Do these characteristics lead to or provide any insight into whether or not the patent that is issued is going to be litigated? And the answer, based on the data set that we have, excuse me, allergies have been particularly bad in Virginia this year, but the data set that we have suggests that the answer is yes. And it is not going to be, I think, what most people think. Spoiler alert, since Megan gave her spoiler alert, is pay attention, because I think most people would think that examiners who are issuing the most patents and doing the work quickly are probably the ones who are likely going to make mistakes and issue maybe bad patents and lead to patents being litigated and then challenged and all kinds of problems arising around those patents. And that's not what you're going to see. So you're going to see quite the opposite. So let's just get going. We have a lot of slides, uncharacteristic for one of our webinars, but it's a dense area where the slides are really going to tell the story. So Megan, let's get going with your slides. I know you're up first, so I'll push your background on variability.
Yeah, so, it really shouldn't come as a surprise to us that the identity of the examiner could have an impact on whether or not your patent is litigated, because we know for a fact that the identity of your examiner affects whether or not your patent gets granted in the first place. We know that there's two distinct kinds of examiners at the patent office. There are those who think that their job is to grant patents, and those who think their job is to keep you from getting a patent. So this is an old study that Sean did years and years ago, but it's equally true today, which shows that a very small sliver of the examination corps is responsible for almost half the patents that come out of the office every year. And on the opposite end of the spectrum, there's about a 20% sliver that's responsible for less than 1% of the patents coming out of the office every year. So obviously we know that who your examiner is affects whether or not you're going to get a patent. And then of course there's examiners everywhere in between. And if you go to the next slide, what you see is that these different types of examiners exist in every technology space at the patent office. I picked these technology centers because they represent some of the easiest and hardest areas at the patent office. So you can see 2800, which is one of the easiest tech centers, has the fewest red examiners, no surprise. 3600, which has all the business method art units, has the most. But these different kinds of examiners, green being fast, yellow being average, and red being slow, they exist everywhere. And so one of the reasons that I became interested in this study is because I get asked all the time, well, if I really even want to get one of these green examiners? Because I don't want someone who's just going to rubber stamp my patent and then it later gets invalidated in court. And nobody really wants that. So maybe it's actually not a good thing to get one of these green examiners. Maybe you'd rather have one of the red examiners who hardly allows anything, because maybe they're doing a more thorough review of the patent. So one of the ways that we thought we could look at this is whether or not the patents get litigated in the first place.
Yeah,
So
and
I can hand
Megan,
it back
just to
over
stop
to
you right
Sean.
there, that is something that we on previous webinars have actually talked about is, are you better off getting a much more critical review of your patents that are potentially more valuable and worth more? And are you doing yourself a disservice potentially? And we've had people ask us that question, and
Mm-hmm.
and so this is why this information, I think, is really so eye-opening.
Yeah, absolutely. And by the way, somebody asked, do we have data on how examiners are incentivized? We know a lot about the count system, although there have been some changes recently that I don't know as much about. But there's kind of, from what we know of how it's been, at least in the past 10, 15 years, you can get your counts either way. You can reach your counts by issuing a ton of rejections or by issuing allowances. So really, there's ways that the examiners can play that game that could result in them being either fast or slow granters. It can work both ways.
Yeah, and we anticipate, we did the webinar, many of you may recall, and if you didn't have the opportunity to see it, you probably would want to go back and look at it with Commissioner Drew Hirschfeld back in July. Megan and I got the opportunity to talk to him and a couple of his top lieutenants about how they were changing the routing and handling of applications with examiners. And once that was supposed to take place sometime this month in October. And once that gets done and once that gets implemented, we will be trying to get them back. And they had said that at that time that they would be willing to come back and talk to us about everything once it was all implemented. So we're going to be continuing to follow up on that and bring that information to you once it's ripe for consumption.
Yeah.
All right.
But with that, I can go ahead and turn it over to Sean.
Okay, great.
So could we get to the next slide?
Let me push the next slide for you. The myths here. We have three myths.
Okay. Before I go on, I'd like to just add on to what Megan had said about examiner incentives. If you're interested in that, I would point you to the Stanford Law and Technology Review paper that I had from 2012, which is in slide 3 of the deck, and it goes over the two different type of incentive structures that examiners can use to maximize their counts. And really, it's eye-opening how they can kind of still reach their production units, either going through a high allowance rate or through a high rejection rate. And this is because the incentive structure is based on quantity and not really quality. All right, enough said about that. So a little bit about myths of litigated patents. This study actually came kind of as a continuation of that first study that Megan had said, where I really wanted to kind of think about which type of examiner is doing more damage to the patent system, which type of examiner is really issuing kind of litigated patents. And there are 3 kind of hypotheses that I came into this study with. The first hypothesis was examiners who really have a high allowance rate, the ones who are rubber stamping patents, will probably have more litigated patents. If you're not really doing a clear review, then maybe you should get more, maybe more people are going to challenge those patents. And that was my first hypothesis. The flip side of that coin is what Megan had mentioned, which is examiners who issue very few patents and really have a lot of rejections, maybe those guys are going to have less litigated patents because it's gone through the crucible of a really tough prosecution, a really tough prior art search, lots of rejections. It's going to come out gold-plated. And that was my second kind of hypothesis. And then the third hypothesis that I had was that examiners who are really early in their career, who have issued patents, may issue more litigated patents simply because they aren't as experienced as someone who has seen a lot of patents, knows what a good patent looks like, knows what a good claim looks like. And those were kind of my presuppositions coming into the study. Can I get to the next slide? What I actually found was really interesting, and that is high allowance rate examiners actually issue a lower than expected rate of litigated patents. That is, lower than expected, they issue actually less litigated patents than you would have expected. Low allowance rate examiners actually issue the expected amount of litigated patents. That is, compared to how much they should, based on just random chance, it actually comes out about where you would have expected. The big surprise to me was primary patent examiners who really are no longer supervised have a disproportionately large rate or a higher rate of issuing litigated patents. So I think that was the big surprise from this study. Next slide. All right, so the first thing that I wanted to do was just see where are litigated patents coming from. And in this data set, I took a year's worth of litigation, which is about 15,000 or 13,000 litigations, and corresponded them to about 15,000 patents, and then looked kind of to see just where are they coming from. You can see 1,600, 2,600, and 3,600 seem to be the largest areas of technology where these litigated patents are coming from. So biotechnology, communication, and business methods, e-commerce were the kind of higher points of litigation. Next slide. So did you want to do this poll question, or did you want to tee it up, or do you want me to tee it up?
I think Ali is getting it going right now.
Okay. So the first question I wanted to ask is just what type of level of examiner do you think issues the most litigated patents? Do you think it's mainly primary examiners or secondary/junior examiners? And when I say junior or secondary examiner, I'm really just saying, do you have primary signatory authority or do you not? So the primary examiner is the examiner that has signatory authority, and the secondary or junior one is one that does not have that signatory authority. All right, primary examiners, and that is unsurprising. So can I get to the next slide? This is the case. So when we look to see who issues litigated patents, it is overwhelmingly primary examiners. About 70% of litigated patents come from primary examiners, about 20% come from secondary examiners. And when I say both, it's capturing those examiners who are in the transition period, who were secondary in part of the year and then primary in the other part of the year. And this is unsurprising, right? Because most patents get issued by primary examiners. So just by chance, you're going to have more primary examiners issuing litigated patents. Next slide. And here's our second question, right? So here what we're asking is, which type of examiner do you think issues the most litigated patents? The ones who have a really fast rate of allowance, average rate of allowance, which I classify as between 40 to 50 or 40 to 70, I think, patents per year, and then slow examiners under 40 patents per year.
We still see a lot of answers coming in, so we'll give it another second here to collect more responses. All right.
Oh, okay. So here, this question was a little bit more difficult. It seems like people are going more with fast and average. So can we get to the next slide? Okay, so the answer is probably the average examiners. Okay, so here what I've done is taken the entire examination or all of the examiners who have sent litigated patents and then segmented them by how many patents they've issued per year in general. And there are two lines here. The dotted line is the weighted average. This is the expected rate of litigation based on how many patents that group of examiners have issued over the course of all patents that have been litigated. So the dotted line means what we would expect for that group of examiners. The black line is what the actual rate is, all right? So if you have the black line under the dotted line, this means that the actual rate of litigation for these guys, for that group of examiners, is below the expected rate, just based on random chance of pulling a patent from that group of examiners. If the line is above the dotted line, that means that that's a bad thing. That means that that group of examiners has issued more litigated patents than you would expect. And then when you see the stars above the error bars, that means that the p-value is greater than 5%. So those are significant points. And when you don't see the star, that means they're not significant. So I divide this graph into three portions, all right? So those examiners that have 40 or less patents, those examiners that have between 50 and 70 patents per year, and then those examiners that have 70 or more patents per year. So if you look at the first section, those who issue less than 40 patents per year, you see they do about as expected, right? They're not issuing litigated. There's a lot of overlap between the dotted line and the solid line. They're not really issuing patents at a higher than expected rate. Then you get to that middle section, and that is the section where you see a real difference in litigation rates, and significant differences too. In some cases, the difference between 600 and 1,000 litigations. So when you're in that middle section, you see a much higher litigation rate than you would expect. And then you get to the really fast examiners. And what was interesting to me in this case is that you see a lot lower than expected litigation when you go pretty fast. And again, those are probably the most experienced examiners that are able to kind of issue 100 or more patents per year. All right, next slide.
And the other thing too is those examiners that have that level of experience and can issue patents that fast have almost certainly been in those art units for a very long time. Yeah. So they know the art very, very well.
So then I segmented the data further by breaking it up into primary examiners and secondary examiners to kind of see if I can see that split. And when I do that, it becomes even more pronounced, the dichotomy between the litigated patents that are coming from the low rate examiners versus the high rate examiners. And you can see, there's a really big difference where you get into that middle section between 40 and 70. And it also becomes more pronounced even at the slow section, right? So the slow examiners, those who issue less than 40 patents per year, are actually issuing more litigated patents than expected. And then there's a flip. So once you get to about 70 or more, those examiners are actually doing much better than you would expect, and issuing patents at a much lower rate than you would expect. Next slide.
So before we go to the next slide, the one thing that I would just like to say, Sean, about this particular slide, some people might look at this and say, well, how could you be a primary examiner and only issue 5 to 10 patents a year? Now, there are some art units where obviously that is, that's possible simply because, as we've illustrated over the number of years, there's a handful of art units that are, no patent for you kind of art units. But the other thing here is there's quite a number of examiners that fall into the we're not issuing very many patents per year here in their primaries. I would suspect a number of those are also people who are part of the time on special assignment at the office doing other things, and part of the time they're examining as well. So I would just like the people to consider that as well, and not necessarily use this slide as an indictment, because we haven't broken it down based on art unit, which maybe is something we can do moving on in the future. But we didn't do that here now, and so just caution you on using this slide for that purpose.
All right, next slide. So then I did the same thing by looking at secondary examiners. And here, when I first saw these two graphs, I thought that they were almost identical in that there's a lot of overlap between the dotted line and the actual line. So these guys are issuing patents at almost exactly the rate that you would expect them to just by random chance. And of course, as you get more senior, you're not going to see secondary examiners issuing a ton of patents because they're moving again from secondary to primary. And so the more experienced guys are gone from this group. All right, next slide. All right, so before I move to the next group of slides, I want to just talk briefly about the examiner promotion schedule and how it's done at the office. So when you start your career at the patent office, you're a junior examiner, and when I say junior examiner, I mean you don't have primary signatory authority. And you do this for like 3 to 5 years usually, and you're being supervised by a primary examiner. These guys have usually the lowest allowance rates, and it's understandable why. They have a docket that they're building up. So for the first year, their allowance rate is almost nothing because they're just getting geared up. And then in addition to that, they might be a little bit hesitant to allow cases because you probably want to join POPA, which is the examiner union, which makes it, once you're a part of that union, it's a lot harder to get fired at that point in time. And you can only join that union, I think, after 1 or 2 years at the office. So you're going through, you're doing your job for 3 to 5 years, and then if you want to be promoted, you join what's called the Partial Signatory Authority Program. This is a period where they're giving you partial signatory authority, but they're reviewing your work very carefully to make sure that you're not making any mistakes, because they want to make sure that stuff that's getting out there is good. This program takes about 13 pay periods or about 6 months to go through. And then you'll have a period of time where you have partial signatory authority. And you're labeled as a primary examiner at that point in time. In addition, if you want to go to the next level of promotion, then you go through the full signatory authority program. Again, it's 13 pay periods, or about 6 months to go through this program. And you have to have, I think, something like 10 or 11 weeks of little to no mistakes during that period. Again, you're reviewed pretty heavily because after this period, you will have full signatory authority and be able to kind of bind the office with negotiating power in addition to being able to negotiate for the PTO. So that period takes, again, between 6 months to a year, and then you're given full signatory authority. I note that all of these things come with a bump in pay, right? You move from a GS13 to a GS14, but the downside of it is that your production rates go up. Because you move up to the next GS level, you are going to have to spend less time, or you're given less time to examine patent applications. And the reason why is, again, it's based the count system is based on quantity, right? So they're trying to make you go faster because you're more experienced in the art. And so that's kind of what is going on with this promotion schedule. So I think we have another poll question coming up next. And this question is asking you, when do you think in your primary examiner career, when do you think we'd see the most litigated patents coming from? That is, do we see the litigated patents coming from that transition from primary to primary, from secondary to primary? Do we see it kind of early in their career, 3 to 5 years, mid-career, 6 to 9 years, or late career, 10+ years? Oops, I spelled years wrong.
Only once.
Only once, right? I really do know how to spell.
Mm-hmm.
While we're waiting for people to chime in on that, Sean, somebody asked, what kinds of mistakes do junior examiners make? And maybe that'll play in a little bit to this discussion too.
So that is actually the question that I was asking in 2 other papers that I published recently. One is, and I call those 2 papers Patenting Fast and Slow, and I look at both non-prior art and prior art rejections and look to see kind of what kind of rejections slow examiners are using versus fast examiners. I know if you guys want to look at the articles that I published, if you go to ssrn.com, you can look me up under Shine 2, and you can find all of my papers. They're all there for free, and you can kind of see what's going on with how people are using rejections to either slow down or speed up prosecution. But I think we also did a webinar on this, Gene, earlier in the year.
Yeah, I think we did
yep.
too. Yeah.
Yeah. So I would point you to that webinar too in the database.
So
all right.
I'm chomping at the bit to get to this poll because I think a lot of people in the comments and questions here, and probably rightfully so, have been a little skeptical about whether or not they're going to be surprised by anything that we are going to show them here. And well, surprise.
All right, so let's get to the next slide. So here in this slide, I show the breakdown based on years of experience. And what's really interesting is it is in that kind of early career segment of time in the primary's life cycle that you see the biggest kind of difference in the litigation profile. Okay, so what do I think is going on here? So if you look at the 1 and 2 year, there's quite a bit of overlap, and it kind of goes back and forth. But you got to understand that's the period of transition, right? That 1 to 2 years where you're labeled as a primary examiner, but you're under heavy scrutiny, right? People are looking at your mistakes very carefully because they're deciding on if you're going to get signatory authority or not. So at that point in time, I think examiners are very careful before allowing anything because they need to make sure that they want to get that promotion. They want to pass their signatory programs and then be able to examine alone. And then at year 3, that's when you see the real disparity between the expected rate of litigation versus the actual rate of litigation. And you can see in year 4, that difference is pretty huge. You get 600 litigations is what you would have expected, and almost twice as many patents get litigated from this group. So what is happening between years 3 and 6? This is what I think is happening, and this is my hypothesis. As you are a junior examiner, you are allowing cases that are clearly allowable, and you're rejecting cases and forcing the patent applicant to abandon cases that are clearly not allowable. So what does that mean? You're building up a docket of cases that, could be allowable, could not be allowable. There are arguments either way, and there could be some strong arguments one way or another. You're not going to allow those cases and they're going to undergo prosecution. You're certainly not going to allow those cases in your first or second year under the signatory program because you're under pretty heavy scrutiny and you don't want to make mistakes. Then in year 3 or 4, that's when you have primary signatory authority. You no longer have a primary who reviews your work, and you're allowed to bind the PTO on your own. On top of that, your production rates go up. So what are you, and you built up this 5-year docket, 5 or 6 year docket of cases that could be allowable, could not be allowable, and you need to step on the gas. So what are you gonna do? You're probably gonna start allowing some of those cases, right? And what patents are the ones that get litigated? Well, it's when the defendant thinks that they can win and the plaintiff thinks that they can win, right? It's an information imbalance. And because of that, I think that's why we see this kind of litigated patent boom, because examiners are at a point in their career where they're not under the supervision of someone else, and they have to step on the gas and allow more patent, or one way to step on the gas is to allow more patents. You're allowing those kind of cases that are arguably more difficult to pin a patentability problem on, and because of that, these patents are getting litigated at a higher rate. As you can see, that goes down from year 4, 5, and 6. As they start allowing these cases or forcing the applicant to abandon these cases, they're getting rid of these cases from their docket. And then in year 7, you see a flip where now that the examiner has gotten rid of these cases, they're back to being able to allow good cases, reject bad cases, and they've gotten rid of a lot of those kind of wishy-washy cases from the docket, and they're doing much better at that point in time. So this slide, I think, is the most important for this talk. And you can see, I think that it's really a structural issue. Litigated patents are a structural issue really as a function of what happens for the promotion schedule for primary examiners, and less so really maybe even substantively what's going on with your patents. Any comments on that, Gene? I know this is.
Yeah, well, I do. You know, and I've been chatting here with some people who are former examiners, and also based on the knowledge that I have with people who are examiners and have been examiners, is there is a struggle for some examiners to make their production quota goals once they become primaries, and then once they become primaries with full signatory authority, because as you progress through the office, what they expect you to be able to do increases, you know, and a lot of times, you know, when you're, well, let me take a step back. When you're first start out as an examiner, you have to make your goal in order to stay on as an examiner. And if you don't make your production goal, you're not retained. Now, some people will just barely make their production goals and be able to stay on, but a lot of people in our space are perfectionists, you know, and that's what makes you a good engineer or scientist. But being a perfectionist and being an examiner are not necessarily how do I want to say it? Someone who's a perfectionist is not always going to be the best examiner, because you're always constantly going to be searching and not wanting to say yes, when in fact you have to say, well, look, you know, I've done as much as I can do. There's nothing that I can find. I have to move on. You know, and sometimes people don't do that, and they work themselves to death, and you know, it's a perfectionist mentality sometimes that causes examiners to not meet their production goals. And then if you are in that situation and you realize, if I'm not going to make my production goals, then maybe you start, I don't know, maybe you work too much, and then and if you work too much, your quality decreases just naturally, you know, because you can only do so much work before your quality is going to reduce. Maybe that's what explains this. And then after you are there for a long enough period of time and you've hit your goals and you're being retained by the office and you are staying on, I think most importantly, because a lot of times when examiners are struggling constantly to make their goals, they say, you know what, this is really not for me. You know, and some of them will go to law school, some of them will just leave, some will go to different parts of the government, some of them will maybe move up within the patent office to do other jobs. But the ones who stick it out and stay, it's because they figured out how to, within their own person, deal with I'm a perfectionist because I'm an engineer or scientist, but at the end of the day, if I can't find anything, I have to say yes. And when they get into that, they hit their stride. And I think that's when the switch flips. And I think that's what this shows. Megan, what do you think?
I absolutely agree. You know, the only other thing I wanted to dig into a little bit deeper is assumptions about why patents get litigated, because somebody asked a question about, you know, the really fast granting examiners, like, well, maybe their patents are so low quality that nobody ever attempts to assert them. But what this chart shows, it's not showing what gets asserted, right? It's just showing what makes it all the way to court. So it could be that it was asserted effectively, right? We never saw or heard anything about it. This is just the point where, you know, it's actually gotten all the way to litigation. People are fighting about it. So,
Right.
yeah, I totally agree. I think, oh, go ahead.
Well, we have a comment here from someone who says, you know, and this is someone who knows and has walked in the shoes. The biggest hurdle an examiner has is to realize that they're the first opinion on patentability, not the final opinion. And I think that that's true. I think that that's why a lot of examiners on the front end, they spend so much time, just like a young associate, you know, when you're a young associate, we've all had this experience. You spend so much time doing a task, you don't write all the hours down on your sheet that you spent. But that's not a strategy for success, because then the partners don't know how much time you actually spent, and they're likely going to write it down to begin with. So if you spent 5 hours and they were going to write it down to 3 hours, you know, well, now you're not getting credit for the 2 hours. Pretty soon you're going to be working 24 hours a day just to bill what you needed to bill,
Right.
you know, and that's not a recipe for
Right.
success. And you know, so I think some of that goes on at the patent office. And ironically, I think it's with the examiners who are the most conscientious and the ones that you would want to find a way to keep. And
Absolutely.
I
And
don't know what
looking at
the
this,
answer is, but I
yeah, I mean,
know that that
yeah,
problem exists.
like looking at this, I don't think it's any kind of indictment of examiners or anything like that. I mean, the difference between expected and actual rates of litigated patents in that, you know, 3 to 5, 6 year time range is so significant that, to me, this data just, it screams that there's got to be something inherent in the promotional system that is causing this.
Yeah. No, and
Not any
I
kind of
would
failure of the
echo
examiners.
that. I'm not saying anything about examiners here. If anything, I think what this shows is potentially very important information for the PTO management, that we will, in a series of studies and moving forward, hopefully uncover that they can then use. And I think what we're looking at potentially is a need for greater education, training, resources at the beginning of a primary's career, and keep the people who are your most conscientious workers and find ways to make them more productive. And the people who are there that are maybe sinking, and you don't know that they're sinking because they're not telling you they're sinking, you got to identify them and help them and train them. And I think it'll lead to higher quality in a better office. Now, that's the supposition that we have based on what we're looking at here. Now we got to go and think and try and prove that or disprove that. But in the meantime, we wanted to bring this to you because what I think this chart shows is that if you're working with an examiner who has just obtained signatory authority, and you're working on something that is potentially valuable, and or that you know it's valuable, and or you know it's going to be litigated, and or you know it's going to be challenged at the PTAB, you may want to go the extra mile and do more in terms of trying to help that examiner with prior art and spoon feed them in a way that you otherwise may not, to make sure that that patent is as strong as it can possibly be, because I mean, this begs for a deeper analysis. When you have an examiner from the 4 years has double the litigated patents that you would expect, there's got to be some reason for that. That it can't be just chance, it seems to me.
And I would echo exactly what you and Megan had said. This is not an indictment on any examiner. This is a structural function of the PTO's promotion schedule, I think. And going back to kind of where we started out with the causation correlation argument, there are some things that the patent office can do to kind of see if this is true or not, right? So one of the things that I suggested in my paper was, maybe after you get primary signatory authority, reset that person's docket, remove all of those cases from the examiner and give him or her a new set of applications. And if that's the case, then we won't see this kind of allowance of litigated patents, or we shouldn't see an allowance of litigated patents, and we should get back to kind of that reset period. And hopefully we can then emulate more of the 7, 8, 9-year patent examiner, right? So
Right.
that's one way you can kind of at least get to the causation. If all things being the same and we reset the docket, maybe then we wouldn't have this kind of selection bias for patents that are maybe patentable, maybe not be patentable, that have a higher rate of litigation. And that's something that I think the patent office could do fairly easily.
And the other thing the office could do too is they could take a look at their quota and see if maybe they need to ease up on what they're expecting people who have just gotten signatory authority to be doing, because that's what another thing here seems to suggest to me.
Right.
All
right. Do we want to move to the next slide?
I mean, yeah, but one last thought. I mean, when you see this drop off like this to get down to 7 and 8 and the number of litigated patents at that point, there's something going on here that is powerful, I think.
We reached a new steady state for those guys. So just to finish off, then I did the same thing for secondary examiners, and you can see these graphs look almost identical. And here, secondary examiners are issuing litigated patents almost at exactly the expected rate that they would have just randomly drawing patents from these guys. So again, not really a surprise. Well, what is surprising is secondary examiners usually are the slowest examiners and have the lowest rate of allowances. And you would have thought maybe that they would actually have a much lower litigated rate because they're doing really thorough prior art searches, because they are undergoing lots of review, not only by their primary examiner, but by the SPE and possibly by QA. You would have thought that maybe those patents would go through a much more rigorous process of examination, but not so. You're just getting about what you would have expected from a random draw. And again, you don't see many secondary examiners with more than 5 years of experience, because at that point in time, they're starting to be promoted to primary examiners.
Right.
So
the next slide here, sources of litigated patents.
Yeah, so this is an analysis that I did. So, most of what we talked about now is, and most of the interesting correlations that came out of Sean's study had to do with how many years someone had been at the patent office. But I also thought, well, is there some correlation between the red, green, yellow designation that we have in Patent Advisor, right? So red means that they're very slow on average, issuing 6 rejections before they issue an allowance, and green means very fast, on average issuing less than 2.5 rejections before they issue an allowance. So I went tech center by tech center just to see how many litigated patents, and again, this is just litigated in district court, and And I also limited the data set to applications filed since 2007. Is there any particular type of examiner who's issuing a disproportionate number of litigated patents? Right. So the numbers here on the y-axis, this is the percent of patents issued by that examiner group that ended up being litigated. So like in 1600, almost 2% of the patents issued by red examiners got litigated. That's incredibly high. That's a lot of litigated patents. And then the yellow, they had about 1.3%, and green, only about 0.5% of the patents issued by green examiners ultimately got litigated. So what I thought was interesting here is that in most technology spaces, it's about an even spread, right? Litigated patents are coming from every examiner type. But in arguably the two hardest technology centers at the patent office, red examiners are issuing a disproportionate amount of litigated patents in these particular spaces. So I haven't really begun to dig into the reasons why this could be. Probably in 3600 at least, obviously the law in that space is constantly changing. So it's hard to know what the expectations are. So I would expect in general there to be a lot of litigated patents, but it's the difficult examiners who are sending more patents into litigation.
Yeah, and this is going to require more analysis, but there's a couple thoughts that come to mind are maybe these difficult examiners are they're difficult because they keep saying no to patents that are perceived by the owners to be extremely valuable. But that wouldn't necessarily, I mean, just randomly, it's how would all these extremely valuable patents in 1600 just randomly get to red examiners,
I don't think there's a selection bias, but the 3600 actually worries me less because you don't have a weighted average here, right? So you're going to be pulling more red examiners more often just because there are more red examiners in 3600 versus 1600, which I think is a problem, right? Because there we have less proportionally red examiners than in 3600, and yet that number is pretty high.
So
well,
Megan has put this
look
into
at
the appendix, so we have it broken down. So let me just push the 1600 one, since that's the one that is the most probably interesting with given the wide spread. So this is the spread here.
Mm-hmm.
Right. Well, so the first thing, one point I did want to make though, is that each bar does represent just the percentage of that examiner's issued patents that go on to get litigated. So it should be controlled for like the number of red, green, or yellow examiners in any of these tech spaces.
Mm-hmm.
Right. But the other thing is, go ahead, Gene.
No, go ahead.
The interesting thing, if you look at the outcomes, so we define, a good patent owner wins. That's going to be, actually, let me see. How did I define this? I can't remember which color is which. Patent owner loss is going to be red, and patent owner win is going to be blue. So you can see that with red examiners, the outcome was slightly less favorable for patent owners than with green examiners. And what was interesting as I did this analysis for every technology center, in the two technology centers where red examiners issue a disproportionate number of the litigated patents, I saw the same type of trend, right, where the outcomes were worse for patent owners with red examiners than they were with green. And all the other ones where there's kind of an even number of litigated patents coming from each examiner type, it was harder to find any kind of correlation with the outcomes. Yeah, here's the other one in 3600, yeah, where the outcomes for patent owners are significantly worse when you're with a red examiner.
Right. One thing
and for this data set, Megan and I decided to do it from 2007 simply because that was, KSR was decided in 2007. And, going back before that really it's a different era. So, and then if we did it from 2014 forward, that's another different era, but there's just was not going to be enough data to draw any meaningful conclusions.
Right. I might modify this also to look at not count a patent owner loss as no infringement, because
yes,
at that point,
I agree.
It's not really something that the examiner did wrong.
I totally agree. I was so, yeah, I had the same thought. I had the same thought with the data set. I think we should include that too. My only hope was that it would kind of come out in the wash, because in theory there really should be no correlation there.
Right.
So my hope was that, but you're right. We would want to control for that in future studies.
Yeah. Yeah, and talking about controls, we had where did it go? We had so many questions coming in here, and I've been trying to answer some of them along the way. It was somebody asked if we had controlled. I can't find it here.
So they said if
There
you
we
could
go. Control
yeah,
for how these may not be independent variables. For example, slow or fast issue and litigate may be both correlated with how crowded the subject matter area is, or assignment of cases may be influenced by the apparent complexity or contentiousness of the subject matter.
Yeah. So, Sean, I think you did do some analysis that was divided by technology space, so that might account for.
Right. I did. Yeah.
Crowded.
The segmentation that I did was by, tech center. I didn't go down to work group or art unit for this analysis because I wanted to kind of see overall universal trends.
Mm-hmm. Yeah, and like we said, this is something we're going to continue to look at and continue to do some more research and massage the data we already have, because this really requires some additional looking at. But in the meantime, if you go back to this years of service for primary examiners does suggest that there is something significant that happens really at the very beginning of when you get full signatory authority as an examiner. And it's not to say that the examiners are bad in that time frame. I personally think it's they're being too much is probably being expected of them, and they're probably being not having enough resources and training, etc. And that's something the office could do. But in the meantime, that's something applicants need to be aware of when you're prosecuting meaningful patent applications, and that's the type of examiner you're dealing with. That delta there is something to think about. Is that going to change how you're going to prosecute that patent? Is it going to change whether or not you're going to recommend to the client to do a search? Because if I'm circling here with my cursor, because that delta there is really the story, and I think it should be considered, obviously, and you probably are going to want to try and do something different. But we're at the end of the hour here. We're bumping up against the end of the hour. So what I'd like to ask both of you is, what is your takeaway message today for the audience? The one thing that you hope that they remember when they leave the webinar today. Sean, you first.
I guess my take-home message would be litigated patents. You really need to think about it not only substantively about the patent, but what happens structurally at the patent office as far as examination promotion for examiners, because this is a two-way street, right? Not only are you're going to be litigated based on the substance, but what the examiner considers, and who you get as an examiner, again, really controls, and where they are in their career may control whether you get thrown into litigation or not. And that's something that more information is good. Be aware of this, as you had said, when you are prosecuting your patents.
Yeah, I agree. Megan, your final thoughts for today.
Yeah, I mean, I think Sean summed it up really well. It's really important to know who your examiner is, not just for purposes of getting your patent through the office, but for purposes of understanding what's likely to happen afterwards.
Yeah, no.
So obviously we need to do some more studies on this, but I think that this initial data is pretty telling.
Yeah, I do too. I think that it's something that the more information you have, the better prepared you're going to be. And at the end of the day, those patent attorneys and patent agents that are willing to work with the examiners are going to wind up getting better results for their clients. And I think what the data set shows today is working with your examiner really requires you to know your examiner and know the stresses that your examiner is under. And we all know that, because we talk about it, we joke about it, that you get the call occasionally on a Friday for the examiner who's looking to make their quota with an offer to allow a case, and that offer is valid until like 2 o'clock that afternoon. So you know the examiner needs to make a count that day. So you work with the examiner. You understand the stresses the examiner's under and why that call is being made. What we're suggesting here is if you understand more about who your examiner is and where they are in their careers and the stresses they're under with respect to their quota, and also where they are in their career development, that may influence the effort you put into the prosecution and more of a teaching role with respect to the prior art, and hopefully less of an adversarial role, because a lot of those examiners that just get signatory authority are overwhelmed. I can tell you that for sure, based on the production quota that they need to meet. So helping them is going to help you and help your clients. There's nothing illegal or immoral or insidious about that. That's just the way that it works. That's the ex parte process. So I really appreciate you guys being here with me today. Sean, Megan, thank you. Thank you to LexisNexis and the Patent Advisor, being a great sponsor of ours. So please check them out. I know they offer a free trial, so you can't go wrong with a free trial, right? So just give it a check. I think you're going to really like the information you can get from them. So hopefully we will see you back in another webinar here, but that's all we have for today. So thanks for participating, and we will see you soon. Have a good weekend, everyone.
Thank you, everyone.